Federal judge dismisses Trump administration's lawsuit against Chicago's sanctuary policies. Picture this: a high-stakes battle over who calls the shots on immigration, where a federal judge just sided with states' rights by dismissing the Trump administration's attempt to challenge Chicago's sanctuary policies. It's a decision that underscores the tension between local autonomy and national authority, and it's bound to get people talking. In a detailed 64-page ruling, Judge Lindsay C. Jenkins, appointed by Joe Biden, agreed with Illinois' argument that the federal government doesn't have the legal footing to bring this case forward. At the heart of it, the judge pointed to the 10th Amendment of the Constitution, and which acts like a built-in check on federal power. Think of it as the Constitution's way of saying that if Washington doesn't have explicit permission for something, it's up to the states to handle it. In this scenario, Illinois chose not to join in on civil immigration enforcement, and the judge said that's perfectly protected under that amendment. No strings attached from federal law. But here's where it gets controversial. The ruling suggests that these sanctuary policies aren't just about local control. They're seen as a shield against what some view as overreach by the feds. The judge even warned that letting the lawsuit proceed would be like a sneaky workaround that ignores the 10th Amendment's boundaries. Illinois Governor J.B. Pritzker was quick to celebrate the win, emphasizing that his state will only help federal efforts when they're done by the book, like with proper warrants for violent offenders. He made it clear that Illinois won't be part of what he calls the administration's oversteps. Meanwhile, the Justice Department hasn't chimed in yet, leaving us wondering about their next move. To give you some context, this lawsuit kicked off back in February, when the Trump administration targeted Illinois and Cook County, home to Chicago, for policies that limit how local law enforcement can assist with immigration crackdowns. Without a criminal warrant, these rules block cooperation on civil matters, which the feds argued was a major roadblock to keeping everyone safe. It's not an isolated incident, though. The administration has been on a roll, filing similar suits against places like New York City and state, accusing them of undermining immigration enforcement. For instance, they went after New York's green light law that lets undocumented immigrants get driver's licenses without sharing data with immigration officials. And they sued Los Angeles for treating federal agents differently. All of this stems from an executive order Trump signed earlier in the year, pushing for penalties like cutting funds to these so-called sanctuary areas. And this is the part most people miss. While sanctuary policies are often praised for building trusting communities, imagine an immigrant feeling safe to report a crime without fearing deportation. Critics argue they create loopholes that could let dangerous individuals slip through the cracks. It's a debate that's far from settled, with strong opinions on both sides. What do you think? Do these state-level decisions empower communities or weaken national security? Should the feds have more say, or is local control the way to go? Jump into the comments and let us know your take. I'm curious to hear how you'd navigate this tricky balance. Judge dismisses Trump administration's lawsuit against Chicago's sanctuary laws. Imagine a world where cities can't protect their own residents from federal overreach. That's the reality the Trump administration tried to enforce against Chicago until a judge stepped in. In a stunning blow to the Trump administration's immigration policies, a federal judge in Illinois has dismissed a lawsuit aimed at dismantling Chicago's sanctuary laws. This decision is a major victory for the Windy City, but it also raises some contentious issues that we'll explore further. In February 2025, the Trump administration filed a lawsuit against Chicago, claiming that the city's sanctuary laws, which limit cooperation between local police and federal immigration agents, were obstructing federal efforts to enforce immigration laws. The lawsuit argued that these local laws directly contradicted federal regulations by restricting the sharing of immigration information with federal authorities and preventing immigration agents from identifying individuals who might be subject to deportation. However, on July 25, 2025, Judge Lindsay Jenkins of the Northern District of Illinois ruled in favor of Chicago, dismissing the lawsuit and upholding the city's right to protect its residents from federal overreach. Chicago Mayor Brandon Johnson expressed his delight at the decision, stating, "This ruling affirms that Chicago's welcoming city ordinance is lawful and supports public safety. We cannot be forced to cooperate with the Trump administration's reckless and inhumane immigration agenda. Illinois Governor J.B. Pritzker celebrated the ruling, tweeting, "Illinois just beat the Trump administration in federal court." Cook County State's Attorney Eileen O'Neill Burke echoed this sentiment, applauding the judge's decision and highlighting the importance of local autonomy in protecting victims and witnesses of crime. So, what's the real impact of sanctuary cities on public safety? Some argue that these policies protect vulnerable communities and encourage cooperation with law enforcement, while others claim they put public safety at risk. What do you think? Do sanctuary cities actually make our communities safer, or do they hinder the fight against illegal immigration? Share your thoughts in the comments below. This ruling is a clear victory for Chicago and other sanctuary cities, but it also highlights the ongoing tension between local autonomy and federal authority in immigration policy. As the debate continues, one thing is clear: the fight over sanctuary cities is far from over.